Hi, everyone. Why don't we get started with the programmatic part of lunch? I'm Scott Hemphill, a member of the faculty here. I'm delighted to be included in the conversation today and to see so many old friends in the audience. We're going to spend the next, I don't know, 20, 30 minutes thinking about kind of where we are with respect to a new administration, how to think about the legacy of Microsoft in the present, and it's hard to imagine somebody better to do this with. So let me first offer an introduction of someone who's known to a lot of the folks in this room, Slade Bond, who's chair of the Public Policy and Legislative Affairs practice at Caneo Gilbert and LaDuca. Before that, he was in the Biden administration as PDOG or PDAG, Principal Deputy Assistant Attorney General in the Office of Legislative Affairs, which I understand was something of a vacation from antitrust, because although antitrust was a piece of what he did, a lot of it was trying to snare some pretty big fish on the legislative front outside the scope of antitrust and regulation of industry. Before that, he was known to a lot of us as chief counsel of the House Antitrust Subcommittee, which, among other things, put together the major digital markets investigation that has recognizable components in some of the litigation currently being pursued by DOJ and by FTC. I should say, by way of initial disclosure, I'm involved in a couple of those cases. In the case of the FTC suit against Meta, I'm working with the Federal Trade Commission as their testifying economic expert. And in the Google search case, I'm involved on the plaintiff side with the states, Colorado and Nebraska, that have brought that litigation in conjunction with DOJ. But I speak only for myself, and perhaps not even then, depending on what we end up covering. So first, please join me in welcoming our
Thank you so much.
Our speaker. So just to kind of get this kicked off a little bit, we've heard a lot about the Microsoft case already. We've heard some war stories. We've heard some applications to the present. And I want to focus on that latter here and try to think about, I don't know if it's the shadow of Microsoft or its kind of projection into the present, and partly as a matter of policy, but also as a matter of personnel. Some of the folks who were deeply involved then are still deeply engaged in the questions that we face today, as we've already heard from this morning. So with that kind of vague prompt, let me kind of kick it off to you a little bit.
Thank you so much, Scott. And it's such a pleasure to be here. It took years in the making, and I just want to thank Professor First and Professor Fox in particular. We had tried to get Chairman Cicilline up here several years ago, and COVID happened, and it's one of my great regrets. And so when I was invited, I was so eager to come just to really pay tribute to all of your amazing leadership in this space, which of course shaped our work as well. But to take a step back, so I was the chief counsel in the House Antitrust Subcommittee. I led the top to bottom review of digital markets as part of our antitrust work. And a lot of the themes that I've heard today really animated that work. In particular, I'm reminded of something John Newman said earlier in the context of the Microsoft case, where it'd be nice to have some antitrust law in these antitrust laws. And if perhaps Congress did not take a half a century to a three-quarter century approach to antitrust oversight in the way we did, we would have some of those clarifications. I'm also reminded of something John Baker said, I think called himself an antitrust cicada. And hopefully I can come back in 15 years and describe the laws that were passed and how important they were and gap-filled a lot of the ambiguities that were identified today, because that's really, really important to what we did. And I told Professor First that I would flatter him, but I really want to start by saying that some of the academic work in the space really inspired us. So like antitrust democracy deficit in particular, something Tim Wu has written about as well, was very motivating and inspiring for me personally, because it kind of lays out this sort of case, if anything, against Congress in this space. And it's important to remember how much inaction there really was for years and years and years in the antitrust wilderness between Microsoft and Google. And that antitrust inaction did a couple of different harmful things that are I think accurately identified in that article. One is it created a sort of echo chamber of problems and problem identification in a way that made it impossible to do the work of oversight. I think the line was the thin diet of efficiency that was fed to antitrust, and how that ultimately harmed Congress's ability to understand the law, to understand developments, to understand economics in a way that was robust and meaningful, to actually do oversight of the antitrust laws, because it is important to remember that the space of Congress here is not law enforcement, right? It is not, bringing a case before a court and convincing by preponderance of the evidence that you proved your prima facie case, and then depending on what case we're citing, responding to an assertion of pro-competitive justifications by the defendant. No, you are making the case to the American public about whether or not the laws are working, whether or not the executive branch is working, and that was core to what we did. And so how Microsoft fits into that is really in a couple of ways. I think the spirit of Microsoft, more so than the actual letter of the law of Microsoft, was very inspiring to us. So you see, it's almost like a lot of echoes of the Microsoft case in the report itself. So we drafted a 450-page report that documented many of the problems we identified. I was actually very touched by Dan's remarks about being an antitrust spy, because we talked to hundreds of market participants, and they're terrified. Like, they would not talk to us without a friendly subpoena in some cases, and they certainly would not testify in many cases. And on the question of alacrity and antitrust enforcement, one of the things that one market participant said is like, hey, I don't want my building to be burned down and rubble and flowers growing in its place by the time the firemen show up. I want accountability and action, and that is something that we try to shed a light on. But to come back to the immediate question, one thing we did, and we haven't talked a lot about this publicly, but one thing we did ahead of our hearing, which was the first time the then 4 CEOs of the 4 of the 5 really dominant tech firms testified, is we had Brad Smith come and talk to our members. And it was not, and he's the president of Microsoft, it was not about tipping points and network effects, although he talked about that from his perspective at a very large firm. It was his experience having lived through the Microsoft case. And his perspective wasn't, oh, gee, we were vilified and Bill had to testify and what a shame that was in 1998, and I can't believe the DOJ raked us through the coals and we had a good settlement in place. No, it was accountability is good. Accountability is healthy, and going through antitrust enforcement made us a leaner, better company. Microsoft would like a word with that, but the point being that it's helpful for members to hear from a person in the business community that no, scrutiny is good, it's helpful, it creates more healthy companies. And I think Microsoft was a $1 trillion company at the time. I checked their market cap this morning, they're $3 trillion. It's not like any of the stuff we did or the FTC did has really dampened their ability to grow at immeasurable paces. So that's the first and second way. And the third way, and you can really see this kind of in how we approach the issue, is sort of the spirit of the investigation. So we actually borrowed from the Microsoft case for our slides at the hearing. We really modeled those after the slides in the Microsoft case. It was like one of our little homages. And so if you go back,
like an Easter egg.
Yeah, a little bit. It's like citing brown shoe in Google. It's like a funny thing to do for no one. It's not actually funny. And so the point is, though, that it was like something that was meaningful to us, to me, Lena, Amanda, and Phil, and the people that worked with us, and certainly inspired us, and we drew great inspiration from it.
Let's talk a little bit about legislative efforts, given that although antitrust is only a piece of what you were doing in your most recent role, it's probably one that's front and center for a lot of us here. There were a bunch of bills. We didn't, in the end, see incremental regulation of big tech firms. How close did we get? What would it have taken to get it over the line? Just any sort of reflections on that process?
I'm not one to quote Joe Manchin very often, but he said in December 2022 there was no good reason not to have a vote. So I'll just leave it at that. In one sense, we're as close as it gets, but I do want to have like an optimistic view of the state of play, while also being really clear-eyed about some of the challenges that we're facing, both in the antitrust lane and then as a country more generally. So in terms of the way back 2022, it feels like 10 years ago, we had bills out of committee in both chambers. The American Innovation and Choice Online Act, which I was one of the lead authors of, had passed out of the Senate Judiciary Committee 16-6. Around this time was 4 years ago, and it was one where we were whipping, and we had something like 10 to 15 Republicans minimum in our back pocket, 20 if Grassley's projections were correct. And so that's a scenario where I think if it had been put on the floor, you would have seen the same type of vote, maybe not quite as high as the high water mark, which was ultimately what the vote for the Merger Filing Fee Modernization Act was, 88 to 8, but something close to that. And you've seen that more recently with tech accountability legislation. The Kids Online Safety Act passed most recently in December with a 91 vote margin, and that is just, those are incredible numbers. And that goes to the point of these are incredibly hard things to vote against when they have a vote. And it's much easier to kill them just by not having to vote on the thing. The second point to remember is back then, and it's different than the House and the Senate are now, but back then, because the margins were so tight, you really had to originate something that would become law from the Senate. And so we had a process that was called pre-conferencing. And you saw this all the time. So we enacted 19 bills into law while I was there. That included the CREATES Act, the filing fees legislation, and also included the first responses to Me Too in the wake of some of the scandals from 2015 onward. And to do that, you really have to have a robust dialogue between the chambers before bills even out of committee. And so, back when we were considering the American Innovation and Choice Online Act in the House, we were having these really robust conversations with the Klobuchar office. And they wouldn't introduce the bill for months after that because they were in the middle of, again, this is the way back machine, but Infrastructure Week, like that was back when the infrastructure bill became law. And so we were sort of pre-conferencing a lot of these ideas. I recall that Tim Wu and I would be on conference calls or Zooms like late into the night and then starting again early the next day to make sure that we had input from his perspective and from his seat in the National Economic Council. And we worked incredibly closely with the Justice Department. And there were things that we changed in these bills to reflect the input and technical assistance we received that they were not sacred cows, but something close to that in terms of, well, we'll never change that definition. And then that feedback was really helpful and productive in the process. And I say all that to say that a lot of that stuff happens under the water, and sometimes bills just magically appear in an omnibus piece of legislation or not, and it just seems like it was easy. But that work is essential to actual lawmaking. And then the last point I would make, in terms of like how close you are, is to the extent that we fell short. I have great optimism, not necessarily in this Congress, but in the next 4 years of changes happening. So this Congress, you have a Republican House that's not quite in sync with this administration, and you're starting to see interesting friction between House Republicans and the executive branch, particularly around antitrust. The story is much, much, much different in the Senate, where there's really robust leadership, particularly among Senate Republicans, in a way that I don't think we've seen in our lifetimes. And you really have to hearken back quite a long time to think of an analog. But I'll just sort of name some names. Senator Thune, the majority leader, has been one of the most robust supporters of antitrust legislation in our lifetimes. He's not very vocal about it, but he was a lead co-sponsor of Senator Warner's Access Act, which really was like kind of groundbreaking in this space years ago. He was also the lead sponsor of the TikTok legislation, which is one of the things that I worked on at the Justice Department. And so you have him in leadership. You have Barrasso, Cotton, also in leadership, also strong supporters. Cotton, of course, had one of the most forward-leaning merger bills ever written as relates to the tech platforms. And he, of course, was one of the co-sponsors of the legislation that ultimately became law that would increase scrutiny of acquisitions involving foreign adversaries. And that's just leadership. So you get to the committee and you kind of go down the rank and file where, Chairman Grassley, he carried in his wallet a copy of the bill names everywhere he went. And so Senator Klobuchar would go up to him and say, Chuck, when are we going to have our markup, this, that, and the other? And he'd pull out, the list and say, I haven't forgotten. And that is the current composition of the chair of the Senate Judiciary Committee. And you keep kind of going down, and I think the tide has turned a little bit in this conversation. And that's one of the things I'm optimistic about. You went from 10 years ago, Senator Lee being very skeptical of antitrust reform to now he has campaigned privately and somewhat publicly in support of the nominations of Gail Slater to be the Assistant Attorney General of the Antitrust Division and Mark Meadow, his former counsel, to be on the FTC. And those are very positive developments from my perspective. So that's like the near term. Longer term, I think you kind of have to look back to what changed between the 116th and 117th Congresses, so the 2019 to 2020 range. And that's where we were able to enact the CREATES Act, where you had a Democratic House, a Republican Senate, or a Republican White House. And you can actually do a lot in that environment. A lot of stuff can happen where you just have a vote, right? or bills have a chance to get into larger vehicles. So I'm optimistic long term. I'm a little bit more pessimistic near term, particularly in the House. But that's not to say that nothing can happen. So in the House, I think that there's a lot of consensus around three main topics. The first is the App Store issue. So that's an issue where we did not mark up the bill, frankly, because we did not want to have a negative vote where members would be locked into opposing the bill simply because Jim Jordan opposed it at the time. But that's a piece of legislation that passed 20-2 out of the Senate Judiciary Committee back in 2022. And when we tried to hotline it in the Senate, it only had one hold that we were aware of. And so that's a bill that we know can pass the Senate. And then the House, I think that you see this sort of changing tune among lots of really powerful executives about the power of Apple as a gatekeeper. And it kind of reminds me again, this is a very simplistic comparison, but of the TikTok legislation where you have like one really unsympathetic company that is creating a problem and lots of other companies on the other side of the issue. And I could see that as being an area where Congress is more active in the short term.
Could you take just a minute to say what the App Store bill would do?
Yes, so we had the big American Innovation and Choice Online Act that was, I viewed it as a telecom act for the internet. We viewed it as like a major update to sector-specific rules. The Open Apps Market Act gets at very specific concerns relating to Apple and Google's gatekeeper powers as it relates to the App Store. In particular, envisions a world where you have third-party app stores available to you, the ability to communicate with your customers directly. One of the most important features of it, though, is that it gets away from antitrust as we think about it. And it more clearly establishes sort of rules and prohibitions and less of a harm to competition requirement, which is ultimately where ICOA ended up in something that was like a major trade in terms of Republican support in the Senate.
And how do you see the prospects for AICOA? I mean, I just want to add one sentence.
Yeah.
As a sort of log line telecom act for the internet,
Yep.
that probably wins some fans and probably makes some enemies too, is my
Sure,
guess. Like,
sure.
exactly, a telecom act for the internet, what could be worse? Some might.
And it's funny because the Telecom Act for the Internet, like if you go back to the legislative history, you really have to go back to like Ann Bingham testifying about breaking up Ma Bell in the early 90s and the pro-competitive benefits of that and how it really spurred this era of broadband deployment and fiber deployment that we wouldn't have seen in the absence of breakups. And that led to the 94 Act, which didn't become law but passed out of the House before the Newt Gingrich change. And the bill, in many ways, was deregulatory after that, right? And so even though Telecom Act may have its own baggage, what we saw with it was a non-discrimination regime. We saw something that gets thrown around a lot in the legislative process, which is something that was described as a bill of attainder by the Baby Bells. So there was litigation in 1998. It was Bell South about whether or not just naming the Baby Bells was a bill of attainder. And so that's something that had its own life. For us with ICOA, I think it's going to take a while for it to come back, partly because you don't have the same forces in the House that we had 4, 5, 6 years ago.
Mm-hmm.
You don't have the Republican leadership of Ken Buck, who really took on his own party quite courageously, in my opinion, not just on antitrust, but on other matters. And I told David Cicilline this after the Google case came out, and he gave me a call, and he's like, that's basically our investigation. And there's like a sliding doors moment there of like, okay, well, this went to antitrust enforcement and not legislation. But he's not in the House either. The thing that gives me a lot of optimism, though, is, from my perspective, one of the silver linings of this past election / maybe 2 election cycles is you have new sort of fresh blood coming into the system that cares about these issues quite deeply. And so if you go sort of the list of freshmen in the House now, you have Maggie Goodlander, who was a DAG in the Antitrust Division under Jonathan's leadership. She was also Deputy Chief of Staff for Attorney General Garland. She's someone who cares deeply about these issues. You have one of my former counterparts, Josh Riley, who worked for Senator Franken, a freshman from New York. He and I worked on arbitration issues together, but he was also a trust buster. He and Alvaro Bedoya are quite close. And you kind of keep going down the list, and you're like, oh my God, this is kind of like a Watergate for antitrust in the House, just hanging out. And so you have those. You have Chris Deluzio's, who is now a sophomore member. So that's interesting. And the second thing is that in many cases, these members are coming from very moderate districts, very frontline type districts. And this is like one of the harder things for members to be tough on is antitrust, because it does not break down along party lines. It's inherently about taking on corporate power. And you find that Republicans that take on corporate power have the same anxieties as Democrats who take on corporate power, because you're basically taking on bullies, and it's not easy to pick a fight with a bully in the playground. And so that's the type of fight that you have to have. But I'm very encouraged. I think that we're sort of at the beginning where we don't yet have the infrastructure, particularly in the House. And I think that the next 2 years, that's going to be really critical in terms of like when the plan for, the ICOAs, the America Acts, the OAMAs of the world reveals itself. It's really important that it doesn't fall through the cracks.
And the political difficulty that you described with respect to standing up to corporate power, I guess, would also predict relatively narrow targets. I mean, when you mentioned the App Store bill, you're not taking on the entire economy, you're taking on,
Right.
a company or two. Is that true of the other things that you see maybe making headway? You mentioned three.
Yeah.
One of them was the App Store bill. Is that true of these other two bills that might have headway as
Yeah,
well?
and we can take it a level up beyond tech antitrust to healthcare. Look no further than Buddy Carter, who's the new chair of the Health Subcommittee on Energy and Commerce, former independent pharmacist, and who just hates PBMs as much as anyone could. And he's actually an interesting person, not just because of his advocacy around this issue, but he's pulling members with him. And something that I agree with that I heard, I think it was Leah Nyland say recently, is that in the antitrust space, you just need like sort of this gateway drug where you identify monopoly power somewhere, and then they tell you there's no problem, and they gaslight you about the problem, and it's infuriating, and all of a sudden you become radicalized. And we kind of seen that with big tech, where Republicans who have throughout their lives are very libertarian, were radicalized by abuse of App Store dominance to exclude disfavored speech, or in some cases really harmful speech. But for them, that was like a very radicalizing moment, and there's like no coming back from that. In the healthcare space in particular, around drug prices, anyone who's been on the other side of the table from one of these dominant, like huge pharma companies, these are infuriating conversations, because it's very much like the laws are not on your side, the facts are not on your side, so you like bang the table and you scream at somebody. And so for staffer, it's like, okay, so please give me your red line. What is your feedback on the legislation? And it's just like anger. It's met with anger. And so for members and staff, that is like infuriating, because it's Article 1 of the Constitution. These members all represent some 700,000 people back home, and no one elected the general counsel from this trade association or that company. And so it's just really infuriating and radicalizing. So in the healthcare space, you could see legislation around like PBM abuse issues, vertical integration that's quite complementary to some of the enforcement activity in that space, particularly reported forthcoming litigation out of the DOJ involving United Health. But going back to tech antitrust, I don't want to be too optimistic, because you also have people who are fundamentally opposed to doing anything, and not in a ideological like I come from this school of antitrust or that school of antitrust. They're fundamentally against doing anything. And so it just so happens that the chair of the House Judiciary Committee, who could very well be the Speaker of the House, this Congress for all we know, is one of those people. And so that's a major barrier to the type of thing happening. And it doesn't mean it can't happen, because it's possible House leadership is supportive. It's possible you can find different legislative routes for doing something. But that's like a huge barrier to things happening that can't be discounted.
Great. Now, I sense from the room a certain amount of like, how can we be this far into this conversation without having talked about the executive branch at all?
Right.
Which, every time I look at my phone, I'm reminded that, things happen
Things are happening.
outside of Congress. And so I'd be interested in sort of shifting our focus a little bit and think about how you see the priorities of the new administration as reflected in personnel, as reflected in expressed policy. I mean,
Yeah.
there's probably some in the room that were very surprised that the merger guidelines seem to be basically intact going forward, and some that would say, of course that was going to happen for reasons that can be explained to me maybe in a minute or two.
So I have kind of run both sides of the gamut. So coming into the year, I was deeply worried about what I would describe as like the interregnum period, where there are all these people who we think might be particularly good on antitrust, particularly in certain segments of the economy, but there are these unknown people working in the background that you've never heard of, that largely have worked in immigration or criminal law enforcement contexts. And I will tell you, these companies were all telling the investors that this administration is going to go soft on them. And you better believe that they've all come back to the table in support of sweetheart settlements, or maybe basically just taking meetings off the calendar. Like in a recent case, and I won't name the case, one of the parties did one of the, well, I thought we could just make this calendar invite go away. And it was on a last rights meeting, right? And so the idea that they thought they could just make it go away by virtue of the change in administration really speaks to some of the corporate hubris that I've been talking about. But one of the things that I've been most optimistic about is, with this new administration, they take this stuff incredibly seriously. And it's hard to make sense of that because, we're barely over season 1, episode 1 of this administration. We saw a bunch of tech CEOs sitting ahead of members of Congress at the inauguration, which as a staffer, I cannot make sense of, former staffer. But, we also are seeing and hearing the evidence of there's a change in thinking on this topic. And so I'll point to a couple of different things. One is in the HPE Juniper deal, this was our first signal that this administration was going to stick to the guidelines. So that cited the 23 guidelines. The fact that it had a quote from Omid Sefi, who's the acting assistant attorney general, who will be Gail Slater's chief of staff when she's confirmed, was our second clue. And how he talked about these issues, I thought was really interesting. And if he were here, he would point out, one, he did not discount the importance of successful businesses. The statement says something to the effect of, these are 2 successful companies, and that's great, right? But 2 is he talked about these experiences of people who are affected by increases in consolidation. And he talked about hospitals in particular and small businesses that rely on these wireless LAN networks or whatever, and how increased costs kind of has a really terrible effect downstream. And I think that was our second signal of like, this isn't business as usual. This isn't like, the return of consumer welfare in the same way that some had predicted. And then behind the scenes, I will just say that, they're of course getting tremendous amounts of incoming from capital, from investors who have the ear of every person in this administration you think they would have the ear of. But by the same token, they keep moving forward, right? And I think they take the attacks that they're seeing in the Wall Street Journal incredibly personally. And I think it's actually making the problem worse for the corporate defense bar, not better, in a way that they're not used to. So in Omid's case, he is a former criminal prosecutor. He's someone that worked in the DC U.S. Attorney's Office. When you walk into the DC U.S. Attorney's Office and you're a defendant, you don't like screw around. You're like there and you're like, that your client can go to jail for a very long time. In contrast, one thing that he said to me is like when people walk in the antitrust division for holiday parties, their heads are kind of held high and they're like a little bit smug in a way that I think, he's taken personally and I think is reflected in some of the animus of the antitrust division. So that's another thing.
So this is a kind of version of the radicalization critique, but applied
100%,
to administration staff as opposed to the
Yeah,
Congress.
exactly. Again, like being across the table from, and so this kind of switching gears, a former Republican official who tells you, well, your theories of harm are absolute bullshit, and this sounds a lot like hipster antitrust. I thought we were done with that. And then you have to look them in the eye and say, we're filing the case tomorrow, right? And that is something that I think, again, like Jonathan is Jonathan, Lena is Lena, Gail is Gail, Andrew is Andrew, they're all different people. But I think that suggests that, we're not going to have the return to corporatism that Wall Street predicted.
So I want to turn to audience questions in just a minute, so start thinking about that. But I guess just one more from me. In terms, looking outside of tech, in terms of substantive focus, sort of roving eye of antitrust across all the economy, are there areas that you see, we should expect an increased attention or a reduction, like healthcare beware? I don't know.
Healthcare beware, right? So, and it depends on the agency, right? So Andrew Ferguson, as chair of the FTC, is beginning to tell us what his agenda is. And part of it, starts out with this like document that, was kind of silly, and then a DEI policy that was, again, the very culture war. And then it was followed by a series of more serious substantive actions. And then that's tempered by, sort of the fever dream around conservative bias and censorship, blah, blah, blah. But at the same time, you kind of see songs that rhyme with Brandeisian antitrust at the very least. But yeah, so in healthcare, I think United stock like plunged through the floor this morning on reports that they've evaded certain, I think it might be Obamacare statutory rules. But that's a huge case that if that is, it's reported there's an investigation at the Justice Department. If that makes it out, that's going to be a huge case. The thing that you and I talked about before this meeting or this panel that I thought was really important is the past administration kind of set off a lot of boats, right? There are a lot of boats that were set off in, particularly in the Section 2 context. So 8 cases under Jonathan Cantor, 3 more recently between Doha and Hamid. And we heard last week from Gail at her confirmation hearing that there are probably going to be settlements and changes of view around settlement policy. But around these huge cases, these cases that take years of staff work, that require tremendous amounts of work ahead of a litigation, those are the ones that are really sticky and hard to go away. And I'm reminded of 2 cases in particular: the Google search case under AG Barr, and then the Meta/Facebook case under Chairman Simons. Those were cases that were started at the twilight of the Trump administration, or at the end of the Trump administration. And they're ones that have continued, and now we're talking about remedies and whether they'll survive appellate review. And of course, the gears turn very slowly, but they do turn, right? And I think it's very hard to walk back those types of litigations. It's much easier to accept a settlement on a transaction that maybe isn't quite as big a deal as one of these really huge ones. So healthcare, beware. Tech, continue to beware. And then I think there's going to be some interesting work around labor, where yes, as a minority commissioner, Andrew, there's a lot of 3-2 decisions. I'm not quite sure what to make of that, because in some cases they were on process grounds. On other cases it was I agree with the premise, but I don't agree this is the right way to go. And yet you see references to labor throughout this administration's approach to antitrust so far. And there was a recent letter lifting up harms to labor in the context of hospital cases. Of course, the FTC has jurisdiction over hospital consolidation. And so you could see kind of a different lens through which conservatives view this. And that's very new, right? That's something that we haven't seen much of recently, if ever. So.
Questions?
All right.
Yes.
So I too was surprised by Gail Slater and thought that was a relatively intelligent choice. But then you look at all of these U.S. attorneys being replaced. How does that affect the analysis in Congress?
Yeah, one of the things that Maggie and I talked about when she was in the antitrust division is like a U.S. attorney could do antitrust on their own. That's the thing people don't really talk about, And you have U.S. attorneys attached to these cases, so it's incredibly important. At the same time, I don't want to prejudge, what person who has really problematic views on January 6th or other things that I would just vehemently disagree with on how they view their role here. And in particular, in the Justice Department, the Justice Manual requires, and this is reflected in this administration's view on the unitary executive theory, those decisions are supposed to come from the top. And so to the extent that you had a rogue U.S. attorney who's not actually effectuating the views of Pam Bondi or her chief chat or, Hamid or Gail, whomever, I'm sure this administration would have to deal with that in its own right. In terms of other folks, it's interesting because, again, I think we have to evaluate them on the basis of their records, right? So it's fun to, speculate and say, well, this person was really good here. So Gail, one of her unsung virtues is she was kind of really essential to explaining antitrust to conservatives behind the scenes. And she worked on that for years in a way that you would never know about, because the whole point of her advocacy was to be non-public. And that postdated her time at Internet Association by quite some time. But if you just looked at her resume, you wouldn't know that. And then it's true for Mark Metter as well. Mark and I went 12 rounds on a bunch of different stuff when he was in the Senate. But he's someone who is very vocally supportive of changes, and he has not yet told us what his views are. I expect him to give a really big speech on the conservative case for antitrust at some point in the next 100 days or so. So my point in saying that is I'm reminded of something Bill Baer would say, which is show then tell, right? We need them to show us what they actually believe rather than telling us in sort of documents or speeches, whatever, to really evaluate where the beef is. Because unless we see evidence of it, it's easy to be encouraged. But again, we need to hold people accountable to the type of record that the past administration had, which was, I'm not going to cut any bones about it. I think it was Robert Jackson, Thurman Arnold level antitrust, right? And that's a very high bar. So I don't want to, assume that just because somebody is, relatable or good on a substance that they necessarily are going to meet that bar. At the same time, I think we're seeing signs of an actual change in thinking that, again, is very encouraging.
Harry.
Uh-oh.
I don't think those remarks were flattering enough, so
Which part of the article did I like best? Well, Harry.
I'm so glad you asked.
No, but I did have a substantive question, which is the legislation to take away the antitrust jurisdiction of the Federal Trade Commission.
The One Agency Act.
Yeah, the One Agency Act, and I wondered what you thought of its chances at this point.
Yeah. So as a alumni of the DOJ, like if you put every DOJ person like and hooked them up to truth-telling machine and they took truth serum, they'd probably be like, yeah, we want all the power in the world. That bill's a problem, right? It's a huge problem. And I'm reminded of, it wasn't at the signing ceremony, but it was a couple years later, Woodrow Wilson had this whole point about how the whole point of the FTC Act is to go when others yell stop, right? And I will say from a congressional oversight perspective, there's great value in the FTC's independence in terms of having really honest conversations about what they're seeing. So I see Daniel Francis in the back. Daniel briefed our subcommittee on sticky defaults before that was like a term that everybody talked about. And we heard directly from agency staff about things that you could never get out of the DOJ because the DOJ also has the Federal Bureau of Investigation, the DEA, all these law enforcement components that create precedents that make it very harmful for oversight. So the One Agency Act, of course, would end antitrust enforcement at the FTC. This goes back to, I think the House is just still really out of sync with this administration on this topic. So you have two things happening this past few weeks that are really like shocking. One is Chairman Fitzgerald, the new chairman of the Antitrust Subcommittee, introduced a Congressional Review Act resolution of disapproval for the merger guidelines, or the merger form, not even the guidelines, the form process, the rule that was recently put into effect. And that's kind of astonishing because he's like trying to CRA his own agency chair's priority, which is unusual. The second is trying to doge antitrust out of the FTC. I think that's just evidence of years of investigating, Chair Lina Khan's leadership and having scar tissue and learned experiences that really, kind of shape at least House Judiciary Republicans view this issue in a way that, again, is not consistent with how the administration is approaching it. I'm also reminded, there was a law review article, or just an article that Scalia wrote in the early 80s, and it was about efforts to codify Skidmore. So this is like in the before times, right? And his point was, hey, we control the executive branch now, guys. Please stop, right? Please stop these efforts to pass the Bumpers Amendment to codify Skidmore because it's going to make our jobs harder. And then, of course, that was before Chevron, which was, of course, an Ann Gorsuch regulatory action at the EPA. So the point is, I don't think that message is like trickled down yet, and I think that it's going to be really interesting to see like if people act out in the next year or so. But certainly, I don't think there's any runway for that bill. And I'll give you two examples of it. So there's few greater defenders of the FTC than Chuck Grassley, right? So he cares about their PBM mission. We'd worked to pass the study bill for years, and that was Grassley driving the car primarily. And then I mentioned Buddy Carter. He's somebody who is at odds with Commissioner Holyoke's thoughts on PBM competition issues. But you are seeing, like, again, like strange bedfellows emerge on different issues where actually they like the FTC. You have people who have grocery stores in their districts who are hearing from grocery stores about, RPA enforcement. And that's something that's never happened before. So I just think that it's not impossible. You could have it passed out of the House again as a symbolic gesture. But I just don't think it has anywhere to go in the Senate. And to the extent it passed out of the House, it would be over the annoyed objection of Energy and Commerce Republicans, which are the authorizing committee of the FTC.
Yes. Yeah. Is there?
Alyssa? I'm gonna pick on Alyssa.
It's coming. Yeah, that was.
Dog-eat. They got dog-eat.
I was wondering if you could talk a little bit about the relationship between the states and the federal government in the new configuration.
Mm-hmm.
I mean, in Trump 1, obviously the Democratic AGs sued the administration on a variety of fronts, but it sort of feels like the actions they're taking now have higher stakes, so it's quite adversarial, obviously. And then also thinking about legislation at the state level, I know there's a version of the Access Act that's been introduced in Utah. Like, what is your outlook vis-a-vis taking some of these ideas and potentially moving them at the state level, given what's happening at the federal level?
Absolutely. So, I mean, it's a really interesting time because there's basically no need for it in the general antitrust space for the past 4 years because the administration was so proactive. And now we're seeing on general basis, New York and California resume efforts to rethink what state antitrust might be, the Donnelly Act, the Cartwright Act. And these are, of course, century-old authorities, 1899, 1907, that, I think don't actually reflect modern marketplace realities in some cases and have their own quirks and idiosyncrasies. And so you have that process on a general basis. On a sector-specific basis, it's really interesting and encouraging. And it's the thing I always wonder is like, what money is behind this, right? Because like you can kind of see shadows of corporate influence, particularly around the App Store issues, where it's like, is Facebook, do they have like an aggressive state-by-state campaign? Because I bet they do. But the point being that, there are things happening. So in Utah, there's also a child safety proposal that's making its way. I think actually it's already passed both chambers. In South Carolina, there's similar efforts. One of the representatives testified this past week about more in the content moderation lane, like 230 issues. But again, like these are all kind of things that rhyme with one another. So I think you have engines of democracy on a legislative level picking up, right? The steam is picking up. We can kind of see the eye-opening of the giant. The other issue is on the state AG side, of course. So 2 weeks ago, Keith Ellison, the Attorney General of Minnesota, former member of Congress, one of the co-founders of the Antitrust Caucus back in the day, made the point that like, hey, we're at the table too. And if we don't have good federal partners, fine, we're gonna keep going. And he name-checked AgriStats, and he went through sort of a litany of cases, Ticketmaster, Apple, Google, et cetera, where the states get a vote too because they are parties to these complaints and are plaintiffs in the litigation. And so that could be good, it could be bad, right? I'm reminded of Amex, right? Amex ended up being Ohio versus American Express. And they don't have the same resources and depending on the state, the same staff that federal enforcers do. But again, I could see a scenario where you have new cases coming out of the states that maybe, are at the far reaches of what the federal enforcers might do. And likewise, this backdrop of accountability of like, states that will not hesitate to continue these cases because like Colorado and Texas and New York have like spent so much time doing it. On the other hand, you also have like levers of power working against reform, right? So in California in particular, the governor has vetoed multiple pieces of legislation that have come out of both chambers. Not clear if that would happen again on a bill that would update the Cartwright Act, and then New York, same analysis with the Donnelly Act. So we just don't know, right? So I don't want to discount the possibility that there's a lot of really good effort that ultimately, only either one applies to 20% of the economy or 8% in the case of New York and California respectively, or two just doesn't happen at all because there's a veto.
John Baker. It's
My
coming.
fellow antitrust cicada. If you weren't here this morning, that sounds very weird.
Thanks. Slade, you described, don't recall exactly the words you used, but essentially new kinds of conservatives on antitrust, with an interest in antitrust in the administration on the Hill. And I'm wondering, where you think it comes from, and in particular, how much of that interest among conservatives in antitrust would you attribute to, hostility to, woke corporations who are suppressing conservative speech, or and how much is beyond that, and where does that come from if it goes beyond that cultural issue?
I wish I knew, and it's like I don't want to be, I'm a lifelong progressive populist Democrat. I don't want to be a person that's like explaining Republicans to a predominantly Democratic audience as a Democrat. But what I'll say is this. So I think there are a couple of things that have changed. Part of it is who makes up the base of voters. I do think that matters, and that in particular around labor issues is important, where you see, Markwayne Mullin with Sean O'Brien. Last year we saw them almost fight each other at a hearing. This year they're like buddy-buddy around the confirmation of the new labor secretary. And that just reflects that a lot of voters that work in labor are more conservative than they were 15, 20 years ago. And I think that's changing how the Republican Party thinks about labor and the importance of that issue across the board, but in antitrust, where it's actually, you can do more in antitrust than you can with the NLRA, just based on a century of bad precedent. So that's kind of general. On the tech side, I do think that there are just like some radicalizing tipping points. And I agree with none of them, but like whether it's the Hunter Biden laptop and Facebook, or Google CEO after Trump was elected the first time, or Trump being deplatformed from different social media platforms. I just think like the worm has turned on that market so much Now, you can't make sense of that and also make sense of the inauguration if you're like a rational person. It's like infuriating. But I think that just goes back to like this administration at this time is like nonlinear, right? There are things that are not going to add up or, you know, pure rational. And it could be a case where like it's not zeros and ones, it's like both can be true at the same time.
Well, there's an uncertainty principle for you.
Yeah.
We'll let that be the last word. Thanks so much, Slade. For joining us.
Good to be here. Thank you again.